Members, we have a quorum. I can call the meeting to order now. This is the meeting of the panel on constitutional affairs. Item 1 on the agenda. Information papers issued since the last meeting. That's a paper forwarded by the Public Complaints Office. I have already passed it on to you. Next item, item 2, items for discussion at the next meeting. Perhaps we could invite the administration in as well. I would like to welcome the administration's representatives. We have Mr. LegCo Members, Under Secretary for Constitutional and Mainland Affairs, Mr. Gordon Leung, Deputy Secretary, and Mr. Chung Toi-ching, Principal Assistant Secretary. The next meeting of this panel will be on the 15th of July. The administration has proposed 2 items for discussion. Under Secretary, please. Thank you, Mr. Chairman. At the next meeting, we would like to propose 2 items for discussion. The first one, voters' registration. This year's voters' registration has been concluded, and we have already announced the provisional register. And we would like to report the progress to members. Some time ago, Ms. Helena Wong sent a letter that is for voter registrations for registered voters' information. Can it be used for other purposes? So at the next meeting we will give reply. That's the first item. Second item, during the by-elections of the District Council, some issues arose from street side banners and so on. So at the next meeting, we would like to have a discussion with you. So 2 items next time, 15th of July. Mr. Raymond Wong, you've raised your hands. Do you wish to talk about the items for discussion or for the next item? Next item, Mr. Helena Wong. I want to speak at the next item. Okay, so for the items for the next meeting, if you have no objection, so those would be the items we'll take up. Let's quickly move on to item 3 on the agenda. Follow up on Equal Opportunities Commission legislative amendment proposal related to the scope of protection against sexual harassment under the Sex Discrimination Ordinance Cap 480. There are 2 papers, one from the Secretariat and one from the administration. Can I first of all invite Mr. LegCo Members, the Under Secretary, to take us through the paper issued by the administration, and then we could allow members to ask questions. Mr. LegCo Members, please. Thank you, Mr. Chairman. All along, the administration and the EOC have worked together on eliminating discrimination and promoting equal opportunities. There are 4 pieces of legislation. One of those is the Sex Discrimination Ordinance. On protection against sexual harassment, the EOC has put forward some proposals, and members have also expressed concern. Now, Section 41 of the SDO refers to protection against sexual harassment for those providing services or goods to customers. And for those receiving services, goods, or using certain facilities, they in turn may or rather, now, those receiving service goods or services, they have protection against sexual harassment under the legislation, but it's not true vice versa. From November to May this year, the EOC has compiled some records on complaints received, and in the paper there's mentioned 2 cases of such complaints. And for such complaints, there is not any legal protection for the time being. That's why the administration sees the need for the legislation to be amended. But if we are to proceed with the legislative amendment, we need to seek the views of members and various parties. This will facilitate our work. Thank you. 3 members have raised their hands. Mr. Raymond Wong, Ms. Helena Wong, and Mr. Kwok Him. 5 minutes each first, okay? Mr. Raymond Wong. Thank you, Mr. Chairman. The EOC proposes to amend Section 40 of the Sex Discrimination Ordinance, SDO, so that the scope of protection against sexual harassment will include customers sexually harassing suppliers of goods, services, and so on. So we know what the amendment is about, of course. The SDO has been in place for over a decade now. I think there should be a comprehensive review instead of just doing patchwork amendments. For example, Section 2(5) of the ordinance, there's a definition. It only covers sexual harassment against women. But then in 2(8), Section 2(8), it says that whenever there's a reference to sexual harassment, it also applies to men. So why don't you just say that in Section 2(5) of the ordinance? So that's a problem in itself. And then, apart from the EOC's proposal to amend Section 40, what about the definition of sexual harassment? Maybe the current definition cannot really keep up with the changing circumstances. There's a High Court precedent, of course. There's about the legal status of transsexuals. Now, the legal status of transsexuals has been affirmed by the Court of Final Appeal. But then under this legislation, is that person regarded as a man or a woman? Would that person be given the same protection as others under the SDO? Australia recently made an announcement. Starting from the 1st of July, they will use the gender X for such transsexuals, and then they will be given legal protection. But now we're talking about expanding the scope of protection against sexual harassment. We're going to have a consultation. We're going to amend the legislation. I think we are actually reacting too slowly because times have changed. So I think the administration must really think about it, and the EOC too, perhaps. Perhaps the Undersecretary could reply in a moment. And on specific aspects of amendments, paragraph 12 of the administration paper, there are various questions. Those are specific issues, and I have some comments on them. First of all, for individual, we don't see the need for legislation for individual services industries. The law should be the same for all. Everyone should be subject to the same law. That's the principle of rule of law. You can't say that for certain trades that there should be more liberal criteria, but shouldn't people in these trades be subject to to be afforded the same protection under the law? So I see a problem there. The second point about more publicity and education of the public, so and educate people about harassment that may take place during the sale or supply of goods or service. Now, you could do this even before the legislation is amended. The third point, expanding the scope of protection. Should it also apply to paragraphs A and B of Section 2(5) of the SDO? Now, on this question, since the administration has put forward this question, then it should really tell this panel what sort of concerns there are. Section 2(5) is about the definition of sexual harassment, but Section 40 is about sexual harassment in relation to provision of services or goods and so on. It's just to expand the scope of protection to cover customers or providers. So I don't really see any conflict there. And what about the legal liability of venue owners or those in charge of the venue? That is, providers, service providers, sexually harassing customers. Is about the consequential liability. Now, if the venue management or the venue owner has no knowledge at all of the sexual harassment, or they've already taken steps to prevent sexual harassment, then why should they be held liable? What about labor insurance, third-party labor insurance? Does it cover that sort of liabilities? I think that's something we need to look into. I hope the Undersecretary could answer these questions. Thank you. Thank you, Mr. Chairman. Thank you, Mr. Wong, for your comments. Paragraph 12. There are a number of questions there. That's why before we put forward any amendment to legislation, we have to consider all these questions very carefully. So we've jotted down all your views, but which way should we go? We have to study that further. You mentioned a point. The STO, or even for other discrimination ordinances, they must all move with the times. They've been in place for over a decade. Some of the provisions ought to be retained, but maybe for some provisions they need to be changed because circumstances have changed. That's why in 2011, the EOC has put forward 11 amendment proposals for our consideration. Actually, we have already completed one amendment. For another 5 amendments, we will be submitting the Rev bill to this Council at the end of this year. And there are still other amendment proposals. We will have further discussion with the relevant departments. And what we propose to explore further now is about the scope of protection against sexual harassment. We would like to expand the scope, and that's why I'm here today, to listen to your views. And it's actually in line with Mr. Wong's comment that we have to move with the times. Next, Ms. Helena Wong. Thank you, Mr. Chairman. The Democratic Party supports an early amendment of the SDO because this SDO was in place before the handover. Now, after the handover, very soon we found problems with the SDO because in the current legislation just says that service providers could not sexually harass customers, so there is protection for customers. But today what we're saying is that the scope of protection should be expanded to cover the service providers as well, so that they will not be sexually harassed by customers. So this was something we omitted in the past, and we need to remedy that. This is something so minor, but it's dragged on for some 13 years. So I'm glad to see this paper from the administration. They told us they're going to do something about it. But the last paragraph, you say you still have to conduct a study and you have to look at the experience of other jurisdictions. I'm worried you might drag it on for another 13 years before you could address such a minor issue. Now, the sexual harassment protection scope, we would like the administration to expand it as soon as possible. Mr. Raymond Wong mentioned the several pieces of discrimination legislation. Maybe there is a need to amend all the ordinances as well, but let's listen to the EOC later on. But this one is straightforward. This is a straightforward amendment. Please proceed with it quickly, because we've talked about it for 13 years. The reason why we find this so important, this amendment, is because by 2012 we have a working population of 3.6 million, and 88% of them are in the services industry. So if this amendment is passed by this council, then there are people working in the service industry, some 2 million of them. They would be given protection by the SDO. Of course, in the service industry, 56% are women, 43% are men, so there are a bit more women than men. But then this piece of legislation protects both men and women. working in the services industry. And it's not just the services industry, the catering industry, insurance, practitioners, lawyers, social workers, nurses, home helpers, carers working in private homes for the elderly, and so on. And of course, the first to bear the brunt would be the beer girls, promoting beer, young girls. They should all be given the protection that's been denied them in the past, and that is they should be protected against sexual harassment. Now, many women's groups have done studies in the past. They would all like to see the early passage of this amendment. So, can you tell us what your time frame is? When can you take forward this amendment? Technical members, as you mentioned, in Australia already there's some reference for us, and also EOC has already done a study on the technical aspects of the amendment. So the Democratic Party supports either the Australian approach or the EOC's approach. So Secretary, tell us when it will be done.
Under Secretary, I completely agree with Dr. Wong that the existing provision is not sufficient. So we should expand the scope of protection to the service providers too. And we have a large number of service providers working in Hong Kong. So the protection is not for women alone, but for men as well. Today, we submit the proposal at this panel so that we can incorporate more views. We hope in the next legislative period, we can come back and report to you. This is almost the end of this legislative term. So, next October. Mr. Ip Kwok Kim. Thank you, Chairman. The DAB all along thinks that we should protect female victims via legislative means. So we welcome the administration's move. And we have to see whether sexual harassment is particularly serious in some service provision sectors. If we have such information, we will know that the proposed amendment is especially important and urgent. In para 12 of the paper, there are 6 issues that the administration says we should consider. I want to know whether there will be any surveys covering several sectors to see whether sexual harassment is particularly serious. For example, young models and beer promotion girls, are they subject to more sexual harassment? Secondly, under existing SDO, the employers cannot sexually harass the employees, and the supervisors of teachers should not sexually harass the teachers, nor should teachers sexually harass their students. Has the EOC received any such complaints? Can I have such information from the administration? Under Secretary. Thank you, Chairman, and thank you, Mr. Ip, for the questions. First question is about data. We understand from the EOC that for the scope of protection, there were 33 cases where service providers sexually harass customers. And we understand that from November last year up to May this year, there were 2 complaints against customers sexually harassing service providers. But this may only be a tip of the iceberg. In the communities, there are organizations conducting such surveys. But regardless of the number of such complaints, we should go forward with the amendment as proposed by the EOC, and we are taking up the proposal of the EOC so that we can minimize sexual harassment. We will provide further information to members in future. From 2008 to 2012, there have been 459 cases involving sexual harassment. We look at those concerning employers, employees, and in educational establishments. For educational establishments, 9 cases. Under Secretary, a reply to my first question, please. Will there be any surveys concerning certain sectors to see how serious sexual harassment is? For example, to survey girls promoting beer. We'll consider your suggestion. But no matter what the number of complaints is, we will go forward with the amendment. Next, Ms. Emily Lau. Thank you, Chairman. I urge the administration to spare more effort in this regard. I hope the proposed amendment can be submitted to LegCo in October. In the past, there were 11 proposals made by the EOC, and 1 of them was taken on board. So what about the remaining, say the 5? I don't know what the administration is doing. If the administration doesn't respect Dr. Yiu-chung, I don't know what he can do. So how come the 5 amendment proposals have not been taken on board? Now, coming back to my question, there is a paper by a women's group asking whether the places reserved for males in PTU and the quota between males and females in police officer recruitment will be changed. For SDO employment guidelines, it has not been amended, revised since 1996. So what's the reply of the administration regarding these questions? For the first question, as far as I know, review is now underway. It will be completed next year. For the first 2 questions, I'll defer to the Deputy Secretary. Thank you, Chairman. All along, the EOC has been reviewing the SDO and putting forward amendment proposal to the administration. Let me give you some figures. In 1999, the EOC made 20 amendment proposals to the administration, 1 of which was completed, 9 of which was discussed with EOC and was found that they require no follow-up actions. It was agreed by the EOC. And there are 10 remaining ones. And in 2001, the EOC made 1 more proposal. So there are altogether 11 proposals that we are following up. What's happening to these 11 proposals? 1 of which has been completed, 5 of which at the end of this year. via statute law miscellaneous, they will be taken up. These are technical amendments, and one of which, as we understand, will not be followed up. 3 of which are in deliberation, and one of these three is the amendment to SDO. So altogether, they make up 11 proposed amendments. What about the issues related to police force? PTU, where places are reserved for males. We will follow that up by the statute law miscellaneous amendments bill. As for ratio between males and females, as far as we understand, some disciplinary forces think they should keep it. For example, the CSD, because they have to take care of inmates of different sexes, they have to keep the ratio. Can I ask for a more detailed paper from the administration after the meeting? I don't just want the figures, I want to know the contents. Now, the EOC has put forward these proposals, but then you rejected their proposal, and in the end, the EOC also agreed with your decision. So wasn't it a waste of time for them to give the proposal in the first place? Amendments they may encounter certain difficulties at the beginning, but after discussing with the DOJ, we found that we may not need to resort to legislative amendments, so they were dealt with in other manners. But this is not the occasion to discuss these matters. I can supply the information to members after the meeting. All right, please do. Next, Dr. Ann Chang. Thank you, Chairman. At present, there are many gray areas. We're not exactly talking about indecent assault, not about issues happening between employers and employees, and we don't know which provision under SDO should be applied in such cases. For indecent assault cases on MTR trains, in the past 3 years, there was a 10% rise a year before last year, but the rise last year was 20%. These are the known cases. What about the unknown ones, unreported ones? I'm sure there are many. It's just that the victims thought it was not convenient to report the case, or they found it troublesome to report the case. That's why they kept silent. When the MTR train is moving, some female tourists said that only on MTR trains in Hong Kong that they would get so close to male strangers. So males and females are pressed together on the train. Males pressed against males, females against males. So when the train wobbles, then you will press closer together. So what can we do? Some people think that the same person keeps pressing against him or her. But this act alone does not amount to indecent assault. So how should we define it? Under Secretary, do you think the examples quoted help your amendment? I think Dr. Chang mentions something that happens day in, day out on the MTR train. What we are discussing today is about sexual harassment under SDO. For indecent assault, it's up to the police officers to crack down on that crimes. Now, there are some occasions that the EOC also concerned with, not necessarily about incidents happening on the train. So for some incidents, both the EOC and the police will follow up on the matter.
Ms. Chang, now, in that case, say on the MTR, let's say we have a special car, and for women who are worried about indecent assault, being victims of indecent assault or sexual harassment, if we have a special car for women only, would it be against the any equal opportunities ordinances? No, there's not such a car, and I understand Ms. Chang has already made the proposal, so let's see how the MTR would respond to that. Thank you. Mr. Yiu-chung, paragraph 6. The role of EOC in dealing with sexual harassment cases. Now, the EOC will handle the cases after receipt of a written complaint. What if the victim is illegitimate? What if the victim is illiterate and she just calls to make a complaint, whatever? Would you then take it up? Now it says that EOC will try to mediate as far as possible. So you try to effect settlement by conciliation. So are you trying to make issues go away, or does the EOC adopt an objective position and maybe instead of conciliation it proposes prosecution? Also, is the EC going to tell a complainant, well, there's not much of a problem, just forget about it? Or would the EOC tell the complainant that the person who sexually harasses you has committed a crime? So what is the role of the EOC? Because you say here conciliation, as if you try to just make the issue go away. And the Secretary, if anyone believes she's been sexually harassed and someone has breached the SDO, even if she's illiterate, she goes to the EOC office. There will be staff to receive her. Follow-up action will be taken and investigation will be conducted. That's the first point. Second point, for the legislation itself, and in fact for the whole judicial system, the current direction is to first try to seek conciliation on disputes before actually taking out court action. Now, of the 33 complaint cases received by EOC, 10 for 10 cases there was an attempt for conciliation. Some were successful, some not. So it's not the case that every complaint has to go to the court. If a conciliation is possible, it actually may benefit both parties. It's not about making issues go away. Mr. Yu? In that case, should you word it this way? Maybe after written complaint or after reasonable complaint, because then the staff might say, well, because you're not putting it in writing, I won't entertain your complaint. So please look at the wordings. And settlement by conciliation, can that be more specific? Also, that's paragraph 6. That is, the EOC will take an objective position in handling complaints. It will provide professional advice, because settlement by conciliation it reads as if you're just trying to make issues go away. You're telling the person not to start so much trouble, just leave it or whatever. Because then people may read it the other way. Thank you. Thank you for your comments, Mr. Alan Leung. Now, on whether you will amend the SDO, particularly Section 40 under discussion now. How would you consider it? Because we read from news reports, say there are female flight attendants, they are harassed by passengers. But the way the SDO is worded, for these flight attendants, well, they are women of, and if there is a male flight attendant indecently assaulting passenger, of course, then he could be prosecuted, but it can't be the other way around. For indecent assault case, of course, it's possible. You can say that a person is indecently assaulting someone. But what about the considerations you have in terms of policy? What do you consider? You say that you can prosecute that person for indecent assault, so there's no need to amend the legislation. Or maybe you think it shouldn't be one way, it should be two way. And then you submit your paper to us. Paragraph 12, you have A to F. Those are the questions. As if there is so much to consider. So can I ask you, therefore, what exactly you're considering? How do you make a decision? What are the factors you have to consider? Thank you. Under Secretary? Thank you, Mr. Chairman. Mr. Leung has pointed out correctly that right now there is only one-way protection. Service providers are not protected. So it does not make sense, and we've pointed that out just now. Legislation should offer two-way protection. That's why our policy is clear. We would like to effect an amendment, and it's hoped that the amendment could be tabled very soon. But before we go to that, there are some questions, there are some issues. Well, it's not that they are tough, but we would like to seek your views on that. Just now some members gave some concrete ideas, comments. So just to give us some ideas, and then we could finalize the proposals and submit it. Now, when the amendment legislation is tabled, of course, there will be a Bills Committee, and then there will be a chance for detailed scrutiny. But before we actually table the amendment bill, we would like to seek members' invaluable comments on the 6 issues you mentioned. Now, when I read the news report, it's just the flight attendants unions have already spoken out on this. And then foreign domestic helpers, they've also asked for amendments. Now these groups, would they be consulted by you? That's my first point. Second question, if is your policy position that it shouldn't be one-way protection, it should be two-way, then there shouldn't be any difficulties in terms of consideration. So could you give us some idea what the time frame is? Okay, today you come here to listen to our views, and then you may be conducting other consultations. But what exactly is the legislative timetable? Do you have one in mind? I think that was mentioned already just now, but anyway, Under Secretary. Mr. Chairman, when we table the amendment bill to LegCo, of course, is after we've done the consultation. We plan to submit the amendment bill within the next legislative session. Ms. Sit Ho, now I've received a case. That's grassroots woman laborer of a contractor of the FHD. She was sexually harassed. We lodged a complaint with the EOC. Of course, very often it's difficult to find concrete evidence because sexual harassment usually takes place when the two persons are alone. Now, even if there cannot be any follow-up, let's say later on the contractor then believes this woman worker is a troublemaker. She is to be transferred from a position in the urban areas to somewhere remote, and so it's difficult for her to go to work, or she's transferred all the time. Now, I wasn't involved in the enactment of this legislation. It was before 1997, so I'm not so familiar. Please help me. Now, is it the case that if any person makes some unwelcome sexual advances to another woman, then that's an offense? But what about the groups or the organizations, if they are biased, or they even take retaliatory action against the complainants? What is to be done? Shouldn't there be any regulation under the legislation? And have you consulted the grassroots women's groups? Now, there could be unwelcome physical contact, of course, but then there are grassroots women workers who may have been sexually harassed, but they dare not say a thing. So what can be done? Is there anything in the law for that, about that? Under Secretary? On consultation, as I said, when we table the amendment bill, I'm sure there will be some consultation work to be done by the Bills Committee. But of course, we will first collect all these statistics and views of groups in the community, or even before this meeting, some groups have made their submissions, and we'll refer to all such views. The other question, you mentioned a case, an FHD case, as an example. Now, would EOC follow up or try to seek conciliation, or when COC finally makes a judgment, I'm sure it will have regard to all factors. It won't just rely on sentence uttered or a certain act done. As Ms. Sitho pointed out correctly, sometimes it's hard to prove it. And for the company concerned, in the conciliation process, should it shoulder certain responsibilities under the legislation? Under some circumstances, if sexual harassment is made possible, or the conditions such that it's easy for sexual harassment to be committed, then the company will have to shoulder certain liability. But for your case, I do not know the exact details. That's why I'm in no position to comment on it. Mr. Chairman, I hope the administration will consider it when amending the legislation. If a complainant lodges a complaint, and if there is a court ruling and the other party is convicted, of course that is the outcome we welcome, though it may not be the best outcome. Still, in the worst case, the court rules in favor of the other party, and then the company may deal with the complainant in some way. How can we prevent any retaliatory action by the company against the complainant? Whereas the person is being brave to come forward and make a complaint, but the complaint is not substantiated, and that person suffers at the end, is really unfair.
Anyone else for the first round? Mr. Chen Chi-chun and then Tony Sher. Thank you, Chairman. I just want to put forward a view. Sexual harassment is not confined to males harassing females, though the other cases provided for under the legislation. A piece of legislation provides a channel for victims to take the case for prosecution is also there to penalize the culprit. So for future amendment, I hope the wording will be clear and the administration should not lopsided towards one sex only. The administration should promote publicity. Some males do not know they are actually victims of sexual harassment, and when they have questions, they dare not raise it under the SDO. So I hope you will enhance education to males and females in future. As Mr. Chen pointed out, victims protected under the SDO are not necessarily females. They can be males, and for the harasser, they can be males or females. So for females harassing opposite sex and same sex, and males harassing same sex and opposite sex, these cases are all covered. Mr. Porcher, I understand from the paper that there are special arrangements required for certain sectors. Section 40 and Section 36, they are about the legal fields. For female legal trainees joining a law firm, when they are on training, they may encounter sexual harassment. How come the legal profession is so special where we have specific provisions? I haven't encountered cases where female legal trainees encounter sexual harassment. And how come you haven't covered or protect the male ones? And the EOC proposed to have a uniform treatment for the 4 discrimination ordinances. What's the administration position at present? I'll take the second question. First question can be taken up by my colleague, the Deputy Secretary. For the review on combining the 4 ordinances, the EOC will take it up. As for the progress, we have yet to know. The EOC is a statutory body. The administration will not interfere with the EOC. And I'm sure the EOC, once survey is completed, will make public the survey and will also make available the copy to the administration. Secretary, Chairman, I have to declare interest on the EOC. The EOC already proposes this combining the ordinances, and now you're proposing to amend the legislation. Is it a waste of time to do 2 things? Actually, Ms. Helena Wong already criticized us on this point, on us being too slow. I also hope that we can expedite things. Deputy Secretary, Section 23 of SDC mentions or stipulates the situation between employers, employees, and partners. I understand that the legal trainee and the barrister do not have employer and employee relationship. That's why when we enacted the ordinance, we have this specific provision for the legal profession so that we will not leave any loopholes. For non-employment situation, will you consider these situations in future amendments? I understand that there's in some sectors the culprit and the victim are not in an employment relationship. We have provision for educational establishment. The design of the SDO is to crack down on sexual harassment, and in particular in certain areas. Sections 23, 24, and 40 and 39 are about specific areas. Second round, Dr. Helena Wong. Thank you, Chairman. Just now, members asked the administration to gather information for us. We do not object to that proposal. However, there are some women's groups that have already conducted surveys on sexual harassment on female laborers. So the administration can approach these organizations for their findings. In 2013, there is a survey conducted on sexual violence. There is a particular chapter on sexual harassment in the report. Now, I understand that the EOC proposes to combine the 4 discrimination ordinances. The Democratic Party does not oppose to that move, but we also do not oppose to expanding the SDO to protect carers, because we have been dragging our feet in protecting these people. We should amend the SDO first before we consider the combining of the 4 discrimination ordinances. Otherwise, we will be moving too slow. Complaints figures is too small. Why? I believe it's because there is no legislative protection. So some organizations may receive complaints in that regard, but they are not taken up. I met with some unions yesterday. Some receptionists working at the jockey club, they are subject to sexual harassment too. Some people call up to the hotline, but then these people, the callers, simply moan and groan. But the workers cannot simply hang up. Another group is the massage girls. The massage girls will be asked by customers to massage particular areas. But these girls, they are not working in a vice establishment. They don't have any intent to do so. But they are not protected by the law. And some dancers who wear tight clothes are sexually harassed by their customers, and they dare not raise a complaint to the boss because they are afraid that they will be sacked. In some private elderly homes, there are lots of female workers. They earn a low income. They have to change diapers for the inmates. They have to serve male and female patients. But sometimes the male inmates actually harass the female carers. That's why I think we should speed up in the amendment, and we should also step up education and publicity to enhance public awareness of sexual harassment. There are already many of such surveys. There's no need for you to conduct new surveys just to rectify the loopholes in the law. Any response from the Undersecretary? No, we will speed things up. Any further views? If not, may I ask the Undersecretary to come back to us when they are ready. Next item, we'll ask the Chairperson of the EOC to come in and join us for the second item. My thanks to the Undersecretary.
首先我代表委員會。
On behalf of this panel, may I welcome Dr. Yiu-chung, Chairperson of the EOC, to join us today. With him is Mr. Herman Poon, Chief Legal Counsel of EOC. Two papers have been tabled to members before the meeting. One is by the EOC, the work of the EOC, the other by the Secretariat of the LegCo. May I invite Dr. Chow to walk us through the paper submitted by the EOC and the future plans for the EOC. After that, I'll open floor for members. Dr. Chow, please. Thank you, Chairman. I'm very glad to have this opportunity to brief members on the work of EOC in the upcoming 3 years. Since I took office, the past 2.5 months, I met with over 130 groups to understand their views. Our future works and our follow-up actions are clearly stated in the paper. And in the paper, we also state the functions and powers of the EOC. We welcome members' views. For our future work, there are 3 main areas. On page 5, members will find that we will work on the education and employment opportunities, and the SDO. As for barrier-free access, we will take up the recommendations in the report in 2010. We'll also amend and revise the 4 discrimination ordinances, the 4-in-1 approach. I understand that members of the public urge the administration to legislate on protection to people with different sexual orientation. Education and employment opportunities for ethnic minorities, students with special education needs, and how to better promote integrated education, disability discrimination in the performance of government functions, to provide a broader definition of disability, to provide wider allowances. All these will be reviewed. We'll start our work in these regards gradually. All right, I'll open the floor for members. 3 members are waiting, 4, 5. Let me read out their names. Helena Wong, Kenneth Chan, Emily Lau, Chen Chi-chun, Sid Ho. Dr. Helena Wong. 5 minutes each. Thank you, Chairman. I welcome the new chairperson of EOC to this panel. One of the functions of EOC is to review the working of the ordinances. And there are some legislation that have not been legislated yet. For example, legislation on sexual orientation. For the amendments proposed by the EOC, how come some of them have been with the administration for 13 years? And how come it seems that the administration only selects some of your proposal to implement? Is it the case that the administration does not really respect the EOC? They allow you a channel to make proposal, but they can always reject or turn down your proposal. As far as I know, since 1996, the enactment of the 4 discrimination ordinances, the EOC made amendments and revision to the ordinances since 1999. And all along, we have kept close liaison with the administration. The administration's response is not as good as we expected. And we think this is a good opportunity for us to review the 4 discrimination ordinances. In 2009, we enacted the RDO, Race Discrimination Ordinance. It's been a decade since the 4 discrimination ordinances were enacted. We have accumulated certain experience, and we hope to consolidate our ordinances to keep up with international practice. As for our communication with the administration and our difficulties in enforcing the ordinance, I'll defer to Mr. Poon, our legal counsel. In 1999, we put forward a series of proposals to the administration covering SDO and DDO, that is the Disability Discrimination Ordinance. At that time, the ordinances have not been around for many years, and the proposals were mainly technical ones. They are related to the implementation of the ordinances. We had discussions with the administration, but the progress was not as good as we had hoped. I remember in year 2003, the administration proposed an amendment to the ordinance, but because of the arrangement at the LegCo, the amendment was not taken up. And after that, we set down a priority for the revision with the administration. In 2011, we drafted the priority list for the administration to consider, and some of the proposals were found to be agreeable by the administration. However, progress is not as good as we had hoped. And so many years have passed. Simply technical amendments are not enough. We need a full review. Apart from the revision on SDO and DDO, we also have to look at the insufficiencies in RDO. And even between the different discrimination ordinances, there are still some gaps. So we are conducting reviews, and we hope we will start consultation with the public and stakeholders. We hope with more views collected, the administration will be more responsive.
Ms. Helena Wong, do you think the administration is not very cooperative? You know, you may knock very hard on the door is still not open to you. Is that the case? Dr. Chow, well, I've only been in post for 2.5 months. It's hard to say whether the administration is being cooperative. Say on amendments to the SDO, we know the administration is all prepared to do it. But of course, we have to see whether there's room for even better cooperation with the administration. The administration set up a committee to look at the sexual orientation and so on. And that ties in with our work as well. We believe that's the kind of work that needs to be done. So we hope to have better working relationship with the administration. But at the same time, we are fully aware that we are an independent body. We also have a role of monitoring the administration. So we have our own list of tasks to take up that we believe would be good for the community. And I have already spelled out all the work plans in the paper. Dr. Kenneth Chen. Thank you, Mr. Chairman. I'm glad to hear from Dr. Yiu-chung that EOC is an independent body. It will monitor the government. So, Dr. Chow, would you state for the record that you would not become an LegCo member, would you? If I plan to take up any other post, I wouldn't have taken up this post. For this post, I really have to sever my ties almost with everybody. So that means I must not be involved in any other organizations. Because in March, when we went to the United Nations, there was much concern. Now, it's supposed to be a statutory body to monitor the government, but the chairperson of the EOC would actually join the LegCo. It's become a laughing stock for Hong Kong. So I hope that Dr. Chow would take note of that. Let's learn from the lesson. Now, I can tell from the paper there are several broad directions, strategic directions, but of course there are limited resources. I'm sure you have plans, time frame. Perhaps you take the first step, second step before you go for 4-in-1, and then there will be also legislation on sexual orientation. But can you press ahead more quickly? For example, the sexual minorities legal protection is not something new. We've talked about it for a long time. It gives the impression that because of limited resources, you have to drag things on further. Now, there are issues of grave concern to the community. Can you not take them all in tandem? The 3 tasks that we're working on, and there are 5 other tasks that we are going to embark upon. So in the next 3 years, we'll be taking up these tasks at different stages. But we believe for most of the tasks, they could start in the next 6 months or so. It's not that we'll just take up one after another. No. For example, the review of the 4 pieces of legislation, the legislation on gender identity, this could be taken up in parallel. And then education or the determination of disability and so on, we could start talking to different government departments to see how we can take things forward. And with our very limited resources, if necessary, we could use them for our own research. Now, you could refer to the experience in other places. For example, the UK, there is the Equality and Human Rights Commission. It has much wider powers, of course. It covers a much wider scope as well. Now, the EOC has been set up for quite some time now. Within your term, would you start a discussion with the community on the protection of human rights and promotion of equality? Perhaps as a statutory body, you could develop further in terms of your powers and functions, so that you could become a body that commands public credibility in protecting human rights. Dr. Chow? This 4-in-1 proposal certainly will make reference to the practices in other countries. So, for example, the UK, Australia. You mentioned UK. Now, many of these other jurisdictions group all aspects of discrimination under one piece of legislation. We have to see, at the same time, we see whether we are doing enough, what other tasks we should take up, and so on. So we will look into all that. This 4-in-1 review actually will cover all these areas. Now it's being done in-house, this review, and it's hoped that at the beginning of 2014 we are able to put forward our proposal for discussion with the public. And it's more than 4-in-1 that we are looking forward to. Hopefully, taking the opportunity of the 4-in-1 review, there will be a chance for discussion in the community. That is, maybe outside 4, we could have the 5th, 6th, or 7th pieces of legislation to promote inclusion and eliminate discrimination and so on. So, could there be such a discussion? Well, there's a global trend. Even in Hong Kong, there is discussion that is all discrimination matters could be brought under one umbrella legislation. So first we must look at the deficiencies of the existing 4 discrimination ordinances, and then we will see if other issues should be brought under the 4-in-1 legislation as well, about religious discrimination, women's issues, and so on. But we keep an open mind as to what to be put under these 4-in-1 legislation. So we have to see what the public think. Ms. Emily Lau. Thank you, Mr. Chairman. I must welcome Dr. Yiu-chung to our meeting. I hope the EOC will have regular exchanges with this panel and report to us your work. The Democratic Party would like to thank the chairperson for taking us out to lunch. We hope we will be able to schedule a meeting with you to talk about issues of mutual concern. Now, I have read the paper provided by the EOC. Paragraph 4. Now, that's an interesting paragraph. Students with special education needs, integrated education, that is, and how their opportunities may be affected. It says here the policy, the integrated education policy, has been in operation for over 15 years, but there has been limited progress. There is still insufficient support or some resources provided. So for students with SEM, they could not pursue equal opportunities in education and employment over their lifetime. And this goes against the right to equal access to education. And such right is protected by a number of international instruments to which the Hong Kong government is bound, in addition to local obligations under the Disability Discrimination Ordinance. Mr. Chairman, is the EOC saying that the administration is acting against the law and it's acting against the international covenants? In September this year, the Committee on Human Rights will convene a hearing in Geneva. I wonder if the EOC will attend. Now, last time in March, EOC attended the hearing. Dr. Cha, I hope you would attend the hearing in person. Are you saying that government is now acting against the international covenant and the law? The EOC has the resources to take the government to court, actually, because the administration keeps saying that these are just international covenants, they're not binding. But we have local laws. So, Dr. Chow, can you tell us more? Because you have you make it sound so serious. So, what do you plan to do? From a legal point of view, we haven't yet looked at the issue. We're just looking at objective statistics. We understand there are many children with special education needs. There is not proper handling of these cases. Primary education, there are some 6,000 on the waiting list. And the service capacity could only deal with 6,000 students, and another 6,000 waiting for services. And every week, every month, the figure is going up, and the waiting time is also becoming longer. That's why it's a matter of urgency for the administration to deal with the matter. I've actually made an appointment with the Education Bureau to see what they can do. And 15-year free education, there is a possibility that students with SEM may not be covered, and that's another area of concern to us. On special education, it's to start with kindergarten. So there has to be arrangement both for kindergarten and primary school. And for these children between the age of 2 and 4, that's a golden intervention period. Only then would they stand a chance to join a mainstream school. So this is an area of particular concern to us. We would like to do more here so that the government could do better. Now, do we have to take a legal approach? Certainly, we will have to consider that. Ms. Emily Lau, Dr. Chow, do work on it, because it's been 15 years. It's still the situation is still appalling. I hope you will write a proper report to the UN, and you should sound a warning to LegCo. You know that you have much support in this council. We have a special committee on it. We're not just talking about kindergarten and primary education. We're also talking about secondary education and tertiary education. So, Dr. Chow, you have to talk to the Education Bureau and give us a paper to report on progress. That's your comment. Yes, I've jotted it down. We'll follow up definitely. Mr. Chen Chi-chun. Thank you, Mr. Chairman. I would like to thank the new chairperson of the EOC, Dr. Yiu-chung. Legal protection for sexual minorities. The administration seems to have great reservation, but so EOC is including this as part of your 3-year strategic plan. And point 2 on page 3 of your document, you've pointed out that sexual minorities are subject to significant discrimination, and there's a need to protect them via legislation. And you aim to consult the public on introducing legislation to protect against discrimination on the basis of sexual orientation, gender identity. And you put it very nicely. You say that, but in a nutshell, you're saying that your views are different than that of the government. But do you have any confidence that you will be able to push for legal protection for sexual minorities? Now, the EOC is going to review the existing, is reviewing the current 4 ordinances. But could that be a stalling tactic? Okay, so you review this 4 pieces of legislation and you merge them into one, and then maybe you try to make things very complicated, to include other grounds such as religious, new arrivals, blah, blah, blah. And so people are concerned that it will be a stalling tactic. But can you make this point clearly? That is, these are 2 separate exercises. They are independent of each other. You don't have to wait for the 4-in-1 before you consider other aspects which are not yet protected by law. So those are the 2 major questions. Now I see that the EOC is going to do so much. That's why at the special finance committee meeting this year, I asked a question. I asked if the administration could tell us whether the EOC has enough funding to do the various work in relation to your anti-discrimination effort. I was worried that you wouldn't have enough money, and the answer given by the administration was shocking. The administration said that the EOC has no plans to carry out any research or publicity effort in relation to anti-discrimination work because it doesn't fall within the jurisdiction of the EOC. So in this reply, what I can see that is the EOC definitely is independent. It's so independent. It seems to be doing its own things. It has no coordination and liaison with the Constitution and Mainland Affairs Bureau. It doesn't matter if you don't have enough money because the government believes that you don't need to do anything extra. You just look at the 4 pieces of legislation. Now, the Bureau is doing consultation on sexual minorities issue, and it has nothing to do with the EOC. So is it possible that you could be duplicating your effort? They do their publicity, you do your own publicity, when you should actually be complementing each other's work?
講啦。
3 questions altogether. Let me respond to them. For the 4-in-1 revision, we have already started that, so we'll carry on with it. As for discrimination against sexual orientation, sexual minorities, whether they should be included in the 4-in-1 approach. We expect the 4-in-1 revision is quite complicated and it will take a long time to be completed. For legislating for to protect sexual discrimination, sexual orientation, this is an urgent matter. And recently there is a case in the CFA. The ruling gives the administration 12 months to reconsider our position. So I am of the view that this matter is an urgent matter. We should legislate for the SODO, Sexual Orientation Discrimination Ordinance. But whether the SODO should be included in the 4-in-1 approach, I think we can consider that in the midterm. Our financial position. We have sound financial position this year. For the coming year, we may have to spend our reserve. We made it known to the government. For new surveys, we have to apply for funding for further resources. Our upcoming work is heavier than the past. I hope we can get member support in our work. As for whether we can complete legislation to protect sexual minorities in the next 3 years, we'll try our best. We will not yield under pressure or different views. We will not slow down. And so we'll continue with our work. Mrs. Ho, I've read the paper and it seems the time frame is different from the chairperson's reply. In para 2 of the work plan, you said that you expect after the 4-in-1 revision, the SODO will start and you will legislate or offer legal protection for sexual minorities from discrimination. Is it the case? I'm quite worried. The 4-in-1 revision is quite complicated. Will it drag on for a long time, even beyond your term? And if that's the case, then we don't know when you can legislate on SODO. I think you can take up the two tasks in tandem. As you've said, one of them is an urgent matter. A transsexual is given the right to marriage by the court. This is a good opportunity for us to review discrimination ordinances and the possible SODO. Now, if the EOC has done a good job in its daily operation, it will help a lot. Now, earlier on, people wonder if the SODO will lead to reverse discrimination, whether it will affect religious groups, and whether it will lead people to commit crimes. If the EOC had been responsible and intervened in a timely manner, you would have helped a lot. You would have helped stopping these unnecessary fears. Will we end up with reverse discrimination after enacting SODO? Now, we have 4 discrimination ordinances in place for 16 years. Have we encountered any reverse discrimination? If only the EOC had responded in a timely manner, the general public, who are not very familiar with discrimination ordinance, would not have been misled. So I think the EOC has not fully done its job. Some people may say they are not discriminating against other people, but then they would embark on speeches discriminating against other people. For example, a landlord may not like to rent his flat to a homosexual couple. So whether or not the EOC takes up enactment of legislation, the EOC should explain to the general public what is the definition of discrimination. The problem is many people think they are not discriminating others. However, they are actually discriminating against other people with their acts, with their speech. So will the EOC do its job in a timely manner? And you are not restricted in doing your job. Dr. Chow, for the time frame, we have already conducted half of our internal discussion concerning the 4-in-1 revision. We expect we can complete the task by the end of this year, and that will be subject to public consultation. For sexual orientation, sexual minorities, and the legislation on these matters, it is an urgent matter. Shall we conduct the two matters in tandem, or should we complete one after another? If we do them separately, we're talking about a difference of several months in terms of completing time. If we conduct the two matters in tandem, it will be confusing to the public. What about your daily operation? You can respond to general public when they're confused. Just let me finish my reply on time frame. We have to liaise with the administration. They have established a committee recently. I have yet to talk to them. I have talked to Madam Chung. In fact, I've already responded to many queries in the media. You may not be aware of that. Some people write me emails almost every day, and I reply to them. Now, the emails are sent to you in private. Can you make the emails public? Say, for example, put them in a blog or in a newspaper column. Please feel assured that in the near future I will write on these issues so that the EOC position will be made clear to the public. You don't just have to explain the matter to the email writer, but also to the general public. We have the responsibility to change people's mindset. They are not in conflict, so please do a better job in making things public, available to the public. Mr. Wong Yuk-man. Dr. Chow has taken office only recently. I'm sure his work plan is the one set down by his predecessor. His predecessor, Mr. Lam Won-kwong, is now the convener of LegCo. I don't know whether you will follow his steps. He has made this precedent, and it's going to be a problem. So I proposed that for an accountable official or a possible accountable official, he should not take up the chairperson role of EOC. Now you are very proactive. You're even so proactive that you express views that are contrary to the administration's position. I hope you are not just giving us empty words, that you will actually review the relevant ordinances. Your predecessor, Lam Won-kwong, was very vocal in saying there should be a 4-in-1 revision. So you should not drag your feet. Just give us a timetable about when the 4-in-1 can be completed. One of your responsibilities is to review these ordinances. But there is one that you do not take up. You've been the chief of a bureau for a long time. And you do not look like your some other bureau chiefs. You do not use public money to buy breakfast. But the problem with EOC is that the power of the CEO also rests with the chairperson of the EOC. I don't know whether you have any views on that. I don't know whether you want to have all the power so you can do your jobs better. So my first question is related to your jobs. And the next question is that the EOC is different from the administration in its position on SODO. Now, I think the administration is not keeping up with time. Even with the CFA ruling on W, even when Australia gives gender X to the third sex, Hong Kong is lagging behind other countries around the world, and we're lagging behind in terms of human rights. In March this year, the United Nations already criticized us on not legislating on sexual orientation or discrimination ordinance. Now, the EOC gets funding from the administration. Mr. Gordon Leung was with the HAB, and now he's sitting beside you. No matter what, the EOC is here to implement discrimination ordinances. I hope you will, or your organization will remain independent. Chairman, coming to my questions about how you will govern, you will run the EOC, and next, the timetable for revision of the 4 ordinances. And the third question, when will we see a review on SODO? Thank you for the question. Operation of EOC. EOC has members appointed by the administration, and we are held accountable to the public. For myself and the 16 EOC members, we are all held accountable. I think Mr. Wong gave an example about the CEO. In the next 6 months, I will see whether there is a need to recruit a CEO. And some senior members may retire within a year. So these 2 matters will be dealt with together. The next question is about the 4-in-1 revision. In early 2014, we will launch public consultation. After the consultation, we consolidate views collected and submit a paper to the administration so that they can start the legislative approach. We'll do our job so that the administration will understand there is a need to revise, to have the 4-in-1 revision. As I said, within 12 months, we have to make a decision. I've met with groups concerned with sexual minorities, with these particular issues, and some traditional groups with religious backgrounds. I've met with them and understand their views. I don't think a consultation will be difficult. Many sexual minorities agreed that they are happy to tell us more if their identity is kept confidential. They can give us more examples. Of course, these will be very helpful to our legislation. The global trend is that we can not avoid or dodge this issue. This is an important time for us, and we should consider legislating on that. Mr. Ip Kin Yun, Dr. Chow has taken office only recently. We should have asked him some broad questions, but my apologies, I want to ask about details. Para 4 of the paper, which is about integrated education for students with SEN. Ms. Emily Lau also raised points about this. Because of insufficient resources and training and support to teachers, there are negative impacts on such students. The EOC will take appropriate action. It stressed there's a need to early intervention identification, and there's a need to have more resources, more manpower, and to enhance public awareness of integrated education. And the fourth point is to beef up the training for teachers. These are very good points. However, they are not very well linked up. Now, the second point is about integrated education for SEN students. And the next point is about putting in more resources for integrated education. Now, the first issue is about special education, which is not in mainstream schools. However, integrated education, i.e., is about putting SEN students to mainstream schools. Resources for IE is not sufficient, as we understand. So I think we should put in more resources for IE. I'm not against putting in more resources for special education. However, this was not clear. I hope the chairperson, that is Dr. Chow, can clarify things. Is it the case that it's not put clearly here, or does it reflect what's happening? The UN report in 2012 in para 73 and 74 is about integrated education in Hong Kong. We have high teacher to student ratio, and the UN is worried that there is a lack of link between different levels of education, and the students with SENs do not get IE.
Dr. Chow. Well, Mr. Yip, of course, knows far more about education than I do. But when we look at integrated education, the concept is that if more children could go into mainstream education, the better. But of course, when these children are in mainstream education, they may have special education needs. That's why there is need for special training for some teachers in mainstream education. So this is what I need to clarify. So we want more children to receive mainstream education. And at the same time, in the mainstream schools, they need to have the expertise to help these students. That's what we mean by this paragraph. We're not saying that we want more special schools. No, we want more resources in mainstream schools for students with SEN. That's what we mean. And we must go further than that in relation to pre-primary education. Now, if there is not any special arrangement in pre-primary education, then after kindergarten, many of these students won't be able to go into mainstream primary schools. It will make things so much more difficult for them. That's why we think we should start at pre-primary education. Now, government regards education issues of the sort as welfare issues rather than education issues. So that's why we need to take a parallel approach. We need to plow in more resources so that students will stand the best chance possible to access mainstream education. In that case, I would suggest you change the wordings. For integrated education and special education, there should be more resources and manpower. That is, increasing resources and manpower for integrated education and special education. Dr. Fernando Chung, of course, I very much share Mr. Yip's concern. Mr. Yip and I are the chairperson and deputy chairperson of a committee on special education. The EOC published a report last year, of course we know. The EOC commissioned the academia to carry out research on integrated education. A number of recommendations were put forward in the report. We have invited the EOC to come and discuss the report with us. Unfortunately, the Education Bureau did not take on board all the recommendations of the EOC. The Education Bureau made it clear that it has reservations on some of the proposals. For example, a new post in schools. Special education coordinator. It should be a full-time post. It should not be just a post taken up by existing teachers. So the coordinator will be able to see whether the students with special education needs are taken proper care of. Right now, in schools, is either the deputy head of schools or a master that takes up the task. But the EOC has proposed a separate post. But then the Education Bureau has said that it has a reservation over the recommendation. So it's not going to be done. So Dr. Charles, thank you for coming to the panel for the first time to discuss with us the work of EOC. But how would the EOC follow up on issues like this? Because in your report you would like the government to do it, but no, they're not doing it. Another point. Just now, Dr. Chow mentioned that early identification and intervention are important. The golden age is 0 to 6 years of age. So if suitable services could be provided during this period, in particular some sort of curative services, it would really help the development of the child later on in life. But if you miss this golden opportunity, you may have missed the opportunity altogether. And that affects that person for the rest of his life. But you know, very often there's such a long queue. Children will only receive such services at the age of 5. So I wonder if the EOC will be more proactive in this respect. Dr. Chow, you were a principal official before, and now you are the chairperson of the EOC. If you find these the policies or the sufficiency of services are such that persons with disability are disadvantaged, or even there could be a breach of the relevant equal opportunities legislation. In that case, if you consider resorting to legal action. Dr. Chow, well, I've already answered this question when I replied to Ms. Emily Lau. Let me repeat myself. Now, there are some 6,000 students waiting for such services, and the service is at capacity right now. There are already 6,000 children receiving the service, 6,000 on the waiting list, and the waiting list is growing. The Department of Health has done a good job in assessment, but then there are far too many on the waiting list. In the past few years, it seems that the birth rate has gone up. So I believe in the next few years there will be an increase in demand. So that's why we have asked the Education Bureau to speed up the work as soon as possible. And we've also made an appointment to meet with the Education Bureau so that they could give us a concrete response. We believe the measures we propose could help these children. It's so important for the rest of their life. Now, if students could receive the service and then join mainstream schools, then they have better education opportunities in future, and the prospects will be better too in life. There's prospects in life. Now, I hope you'll be more specific, Dr. Chow. I don't think there's any argument on the directions, but what if the government doesn't do anything? How could the EOC enforce the law? Now, the Commission on Poverty is already letting out wind that there's nothing they can do about the allowance, and so what role would the EOC play there? Dr. Chow, well, I have not ruled out the possibilities of legal action because the EOC does have the power. I mentioned that point already. And another point about the definition of disability. I think this issue is dragged on for quite some time now in Hong Kong. Rehabilitation services, in particular, disability allowance issues have been affected. So we have to keep up with the global development. Say for disability, we should follow the International Classification of Functioning Disability and Health. If we could do that, it would be better. Okay, no more on the first round, and there are two on the second round, and Ms. Helena Chen and Mr. Shen Chi-chun, 3 minutes each. Thank you, Mr. Chairman. The EOC chairperson mentioned in the paper that you would revise the Code of Practice on Employment under the SDO because since 1996 there's never been any amendment, and there are many new cases. In 2012 there was a new case precedent about transfer of responsibilities. So I hope you will undertake to review the Code of Practice on Employment. Another point, many groups have asked us to convey this. It's hope that you will compile a Code of Practice on education. Now we have Code of Practice on employment, but not one on education. But then some survey findings show that in schools there are plenty of sexual harassment cases. But EOC does not intervene in schools, and the Education Bureau says that schools enjoy autonomy. At the end, nobody takes up, does anything. So under the SDO and the DDO, perhaps the EOC could issue a guideline to schools, primary schools, secondary schools, and even universities. They should all follow such code. And then we have no idea of what's actually going on. We just leave it to some groups in the community to do their own research or survey. Integrated education, many parents say that their children are actually the targets of bully. Some have been sexually bullied. So do consider what you can do. And anti-sexual harassment campaign, I think you should embark on one. Now, now we talk about expanding the scope of protection in relation to sexual harassment, but if people don't know about it, there's no point. So you need to step up your public education effort in relation to sexual harassment and so on. What about schools? What are you going to do? Perhaps the code of practice on education is that schools must report complaint cases. There must be a mechanism to deal with it, and there must be proper training on how such cases should be dealt with. And perhaps there are other areas that we've overlooked, for example, in the healthcare sector, in clinics, in hospitals, in wards for mental patients are sexually harassed, or when people are receiving physical examination, they don't know if that's sexual harassment or if they're being sexually harassed or not. And even for discipline forces, there are complaints. We're hearing cases at the independent police complaints commission. That is, what about physical contact with the other with people of the other gender? How could we avoid sexual harassment and so on? Now, on the code of practice on employment under SDO, we are now doing the review. And just now we also talked about the possibility of amending legislation. We'll see what needs to be included. And on education, we have liaised with the Education Bureau. There will be 4 training opportunities for heads of schools and other officers of schools on issues about sexual harassment. We will also be issuing a series of guidelines, so schools will have specific information to go by, and they will be able to then update their own internal guidelines on dealing with sexual harassment cases. Well, whether there is a need for a standardized approach, well, we have to see, because many schools have already done their own work. But we would like to provide guidelines so they could have some reference to go by in deciding on their own practices in schools. Now, school management is concerned about this issue, and school management could actually assign someone to deal with complaints and provide assistance if students have a need. Maybe sometimes they dare not say too much among their peers. They may just complain at home. But if there's someone a dedicated staff member in school to help them, it will be better. Maybe they would decide whether they should go with the student to go to the police, or whether there's need for special counseling and so on. And for employers groups in Hong Kong, including the Chambers of Commerce, the Federation of Industries and so on, they have all given us they will give us information. So we know if businesses have their own code of practice on dealing with sexual harassment complaints from staff. So we want to find out what the employers are doing. And then hospital authority and other healthcare organizations, we also going to see how tell them how they could deal with the cases. So at workplaces where there is a high possibility of sexual harassment, we will be in touch with all these parties so that we can help them compile proper internal guidelines.
Chen Chi-chun, the EOC is there to monitor the government. However, it seems that the EOC is now a buffer. When the administration is reluctant to do something, then it's up to the EOC to do its job. For example, to take up legislation on SODO. The EOC should urge the administration to take up this job so as to avoid people having this impression that the EOC does not have power. In year 2006, the court ruled that the age for male and male sexual intercourse should be lowered from 21 to 16. However, the court ruling is not made known to, or is something that is not many people are aware of. Another case is the W case. That is 1 year for the administration to consider its position, but I don't think it's enough for the administration to rectify the matters within the law. It's now up to the immigration department to respond to the court's ruling. But the EOC should not just post an essay, an article on the website and think the matter is dealt with. 1 year for the administration to deal with it is not enough, because it has to deal with the legal aspect of the issue and other relevant issues. I think the EOC should discharge its obligation in helping the administration in this regard. With existing resources, we will fight for the rights, the needs of the minorities, including sexual minorities. In the previous item, or in the previous round, another member asked the position of the EOC. Now it's very clear. For any complainants come to us, we are sympathetic and we're concerned about their case when we deal with a complaint. Not all the complaints will be settled by way of compensation or will be taken to court, because we have to look at the evidence. However, I have to say that we are very serious in evidence gathering and in our investigation, but we do our best to help the victims to get what they deserve, including getting compensation for them and to provide legal assistance to them in court. When we spot anything that's any discrimination in our community, we will voice it out. All right, many members have already asked you questions, and the chairperson has already responded to them. Thank you for coming. If you want to come back to report to us, we will welcome you very much. Otherwise, we'll meet you at the regular meeting. Thank you, Chairman. Item 5. Nomination and voting procedures governing presidential elections in selected places. This is a matter raised by members, asking the Secretariat to do some research in this regard. And the Information Services Division of LegCo has already supplied a paper to us concerning this matter. With us on this item is Mr. Michael Yu, Chief Research Officer. Mr. Yu, will you take us through the paper before we open the floor? We have reached the time of our meeting, the end of our meeting, so I propose we extend our meeting. Mr. Yu, over to you first. Chairman, I'll be brief. We'll look at 3 countries. Ireland, France are 2 of them. We chose them because the nomination threshold there was low. In France, there were 10 candidates in the presidential elections, and in Ireland, 7 candidates. In France, they adopt 2-round system and Ireland preferential voting system. Under both systems, the countries can ensure an absolute majority for the candidate so that the candidate-elect will enjoy a higher mandate. The other country we pick for the survey is Singapore, where first-past-the-post electoral system is adopted. And there is a screening mechanism for candidates. The candidates in Singapore has to obtain the certificate of eligibility to certify the candidate is of good character and possesses experience and ability in the administration or in private sector. They have to have 3-year experience before they can get the certificate of eligibility. There were candidates who did not get the certificate and were not allowed to take part in the or to contest in the presidential elections. That's all I have to say in introduction. 6 members are waiting to speak. 3 minutes each. This is just the proposed research outline. We're not in the details. Kenneth Chan, Lee Chak-yan, Regina Ip, and so on and so forth. Kenneth Chan. My welcome to Mr. Yu. Thanks for giving us this outline. I want to give some comments. 2 democratic countries from the West are picked, and 1 democratic country in Asia is also picked. Singapore system enjoys a very low ranking by Freedom House. I think it's closely related to this system and the Lee's family influence. Will the Secretariat make reference with more newly developed democratic countries? For example, in Poland, you just need 10 nominations. You just need 100,000 signatures to be nominated. What about the rights and interests of political parties? In Hong Kong, people who are from political parties cannot take part in this election. What about in other countries? What about the responsibility and interest of people with political parties contesting in this election or the independent candidates? And what about the use of public money or the support of public money in campaigning? I understand in some countries there are restrictions and you can get some reimbursement on that. All right, I'll open the floor for comments first, and then I'll ask the officer to respond. Mr. Lee Chak-yan, I wonder if we need to make reference with Singapore. If you pick Singapore as a reverse example, a bad example, then why don't you pick Iran? Because in Iran, the screening mechanism is even more objective. It's even more subjective. So if you want to pick a bad example, you might just as well pick Iran to look at the nomination committee there and how it operates. I'm serious about it. I'm serious because from that you can tell the negative impact of the system on democracy and on the general public. So I propose replacing Singapore with Iran in your study. Mrs. Regina Ip. The 3 countries proposed are chosen for the study because the nomination threshold there are low. In France, because the threshold is so low that 10 candidates contested in the election. But then in the end, in these countries, the number of candidates is small. And in France, they adopt the 2-round system. The election of CE falls under the Basic Law. Why don't you make reference with the U.S. presidential elections? There are primaries before candidates are selected, and we can always make reference with Taiwan. Mr. Kwok, I don't understand why you pick Singapore. Please switch on the microphone. To study Singapore is just a waste of time, unless you are going to quote it as a bad example. Otherwise, it's just meaningless to study Singapore. I don't think Hong Kong people accept the system in Singapore. So it's just a waste of time for you to study it. Ms. Emily Lau. Chairman, I don't know why the outline took so long. We raised the request on 18th of March, and it's only after 3 months that we have this outline. Maybe the Secretariat does not have enough manpower, but I hope they can offer us timely assistance in future. I agree with Mr. Kenneth Chan. For example, we should look at the newly democratic countries like Poland in the study. I hope this will not increase your workload. Regardless of the threshold, just do the study and do an independent study. And the members can pick what they like from the study. But please bear in mind the study is not just for members, but also for members of the public. Members may ask you to study on the US, Taiwan, Iran, and Singapore. Please look at their studies. Now, for on-air or TV debate, not all the candidates can go or join these debates. Now, these are matters of interest to people. So I wonder if you can include all these countries, all these views, and come up with a well-rounded report. Ms. Ho. Please don't just look at the nomination process, the procedures. You have to look at the whole system to see whether it's democratic. Now, Singapore, there's no freedom of the press, no freedom of assembly, no independent legal system. They may have universal suffrage, but they lack all of the others. And when someone lose in the Congress election, the candidate is actually arrested at the airport when he is about to leave. So you have to look at the whole picture and not just part of the system. Power of president in Singapore is only responsible for ceremonial activities. But this is not the job of the CE in Hong Kong, because the ceremonial activities are taken up by the CS in Hong Kong. So your study should pick countries that can make a comparison, a real comparison with Hong Kong. And secondly, you should look at the full picture of the country instead of just part of the system. Mrs. Ip said that the U.S. presidential election is not a direct election because the candidate is elected by electoral vote. Well, you can also look at other parts of that system. The candidates have a right to stand election, even though there is a high nomination threshold. I hope these can also be included in the study. Mr. Chan Chi-chun, I think Ireland is picked because the preferential voting system is in place there. But the so-called president in Ireland is just a figurehead. So if you want to study preferential voting system, should you pick a country with this system and a leader, a president with real power? And will you consider incorporating South Korea in your study apart from Taiwan and Singapore? Mr. Ip Kwok Him. Thank you, Chairman. for the research team, research office to come up with this outline, I have to express my thanks to them. The research office of LegCo is a neutral body, but members may have their own political interest. Well, it's still fine. The crux of the matter is to incorporate as many political systems around the world as possible. I understand you have to mind resources you spare. You enjoy limited resources only. And you have to come up with a study. A study to see how we can observe the basic law while moving ahead with our presidential elections, to come up with legislation that is in accordance with the current situation of Hong Kong. The CE elections are guided by the basic law and the decision of the NPC. And our system has a number of differences compared to overseas experiences, but we would like to make reference with overseas jurisdictions. Members have suggested many more countries to be considered. I will talk to the research office about these so that more information can be provided to members. We will resume in late September. I'm sure by that time we will have further information. If there's nothing else on this item, AOB, the next meeting will be held on the 15th of July, on Monday, 4:30.